Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing wills in Thailand. So one issue that comes up with a lot of our clients is two jurisdictional. So where we're talking about, for example, an American in Thailand. They have property in the US, they have property in Thailand, and they want to keep their estate planning issues as separate as possible so that it's as easy to deal with as it can be for their loved ones in the event of their passing, in keeping it separated so that American assets are dealt with under American courts oftentimes, Thai assets dealt with over here under the Thai system, and ne'er the twain shall meet, if you will. Where you have a third country jurisdiction sort of come in, where you've got a third country that other assets are in as well, it kind of depends on the underlying facts of the case whether or not it's a good idea to then even have specifically separate estate planning measures in place. For example, a separate will for that jurisdiction as well. At a certain point, it all kind of becomes counterproductive as there becomes so much going on with respect to different wills, different jurisdictions, all the legal work associated therewith, where again, it becomes sort of counterproductive and not really in anybody's interest to basically have multiple different estate planning mechanisms in multiple different jurisdictions. Now that said, in some cases it may be very useful to have multiple mechanisms in multiple jurisdictions. It's always going to be dependent on the underlying facts in the case. That said, specific issues pertaining to Thai wills, generally speaking, even though the person who may be making the will is going to go ahead and want to see their will in their own native language, in most cases that we deal with, that's going to be English, it's also a good idea to have those things drafted in Thai as well. So we do what's called interlineation, where one section is English and then right next to it is Thai, so that it's clear in both languages what is intended in the testamentary instrument, another sort of fancy word for saying the will. That said, where you're dealing with more than one jurisdiction, you may have to take into consideration special factors, if you will, to make sure that the two things don't interact negatively with one another, especially in the event of possible probate, as we call it in the common law vernacular, or succession as called in the Thai civil law vernacular. And then meanwhile, where there's more than just two jurisdictions, you kind of have to do the cost-benefit analysis of multiple different mechanisms associated with estate planning in all of those jurisdictions. As usual, those who feel a bit overwhelmed about this stuff, it may not be a terrible idea to contact a legal professional, gain some insight and guidance into how best to proceed.